a very important development has taken in Supreme Court. The Supreme Court, in the case of Assistant Commissioner Anti-Evasion versus Aerocom Cushions Private Limited, has upheld the judgment of a High Court which followed Gujarat High Court judgment holding that the assignment of long-term lease of land is not a supply of a service, and such an assignment is not in the course of business of the petitioner. Now, the Gujarat High Court case arose where a land allotted to the petitioner who constructed the building thereon was assigned to a third party called Rishta Industries. The department wanted tax on this, holding this supply of service in the notification serial number 35/11/2017, read with section 2B and 2A of schedule 2, read with section 7.1, definition of supply, so to say. Now, Gujarat High Court examined the details of the lease deed. Gujarat High Court, after examining the lease deed, came to the conclusion, and rightly so, that once the original lease deed executed between GIDC or MIDC and the assigner presupposed that the lease deed can be transferred, assigned to a third party, then once the assignment was done, the third party will step into the shoes of the original lessee, and his name will be recorded by the concerned GIDC authorities. Therefore, there is no question of whether the supply of service. And 95 years old lease deed, it can said to be virtually you are the owner of the land. Therefore, this will be arising out of immovable property rights, therefore not taxable. This judgment was followed by the High Court, Bombay High Court, in Aerocom Cushions Private Limited, which followed Gujarat High Court under similarly circumstances where a lease was given by MIDC to the party and a party assigned to third party. Tax was demanded. Gujarat High Court was quoted. Bombay High Court accepted the ratio of Gujarat High Court. Now, sensing loss of revenue, the appeal by SLP filed before Supreme Court. Supreme Court, after hearing the party, said, we do not want to interfere with the order of the Bombay High Court. Therefore, the SLP stand dismissed. Now, what does it mean? Of course, SLP has been dismissed. Supreme Court does not pass a judgment on merits. But this has a huge significance on this issue of taxability of transfer of lease deed rights of land with or without building thereon. Now, once two high courts have now confirmed this issue, and Supreme Court has refused to interfere and the SLP dismisses, in my view, the law seems to be now settled. Okay, in case of long-term transfer of lease deeds, that is 95 years, not necessarily can be 50 years, 45 years, and therefore this may not fall in entry 2B of schedule 2, read with serial number 35, notification 11/2017, read with section 7.1. Therefore, we as professionals can take it settled that these kind of transactions cannot be taxed under GST, as the second assignee steps into the shoes of first assignee and the assigner takes his name into his records. Therefore, this is nothing but a transfer of immovable property, which in any case cannot be taxed. So this judgment settles the score, in my opinion, and all high courts and appellate authorities must follow this. Quote this judgment. It's available in whatever site you follow, the Gujarat Chamber of Commerce and the Aerocom Cushions Private Limited, Bombay High Court, Gujarat High Court, and now SLP dismissed by Supreme Court. Thank you for watching the video.